Good afternoon, everyone. Thank you for joining us for today's presentation. My name is Tricia Riley. I'm the chair of the Labor and Employment Practice Group here at Merthyr Kalina. And with me today is Martha Royston, and we'll be talking to you today about best practices for hiring. I'm just going to go over a few logistical points first. All callers are in listen-only mode. If you have questions during the presentation, you can write them in the questions box of your webinar toolbar, and we will answer them, or at least address them, at the end of the presentation. This webinar is being recorded, and all of today's participants will receive an email following today's presentation with the PowerPoint slides and a link to the webinar and an attendance certificate. So, welcome again to Best Practices for Hiring. First, we just want to outline what we are going to address today. First, we're going to talk about job descriptions, and the reason we're going to do this is that the job description informs the application process and the hiring process. So you need to make sure that your job descriptions are in good shape, that they are tailored to the job that is being hired for, and we'll talk about that in more detail later. We'll talk about the application and what can and cannot be included on an application. We'll talk about the process of screening applications once you've gotten them in. Interviews, then the offer letter, and then very importantly, if the offer letter is contingent on anything, such as a background check or a medical exam or drug and alcohol testing, that needs to be set forth in the offer letter, and we will also talk about the background check and medical exams and that sort of thing as well.
So it's a good idea to start the hiring process by updating the job description for the position that you're looking to fill. You may have hired countless people for the same job in the past, but positions have likely evolved over the years. Your business needs may have evolved as well. So it's important to make sure that the job description accurately describes and reflects the essential job functions, the minimum requirements for the job, and you should revise the job description accordingly. It's also a good idea to include the phrase "and other duties as assigned" just to be safe, but all the important stuff should really be included in the job description. So to give you all a sense of why job descriptions are so important, we have the case of the Rite Aid needle phobic pharmacist from 2017. In this case, a Rite Aid pharmacist was terminated when he was unable to perform immunizations. The pharmacist sued Rite Aid, claiming that his termination violated the Americans with Disabilities Act. In other words, the pharmacist claimed to have a diagnosed phobia of needles that prevented him from performing immunizations, and he felt that Rite Aid should have accommodated him by not requiring him to perform immunizations in connection with his position. Ultimately, Rite Aid was able to prevail in this case, at least in part because the pharmacist's job description clearly stated that an essential duty of his position was to perform immunizations. So, in other words, the employee was not qualified for protection under the Americans with Disabilities Act because he was unable to perform his job's essential functions with or without a reasonable accommodation.
Once you've reviewed and refined your job description and you know precisely what kind of position you're advertising for and what the essential functions of the job are that should be included in the job description, you then have to think about the application. And many of you probably already have applications that you use, but you need to review those now in light of the new law that's been passed and that has gone into effect as of January 1st of this year. Many, if not most, applications ask for salary history. It is now illegal in Connecticut to ask for salary salary history. Okay, so if you have what was your rate of pay in your last job or anything like that, you need to revise your application and take that off. You may ask generally about the structure of the salary or the compensation package. So in other words, if the person has stock options or other equity incentives, that's usually for a higher level employee. So for most of your run-of-the-mill employees who are going to get either a salary or an hourly based pay, you're not going to be asking about stock options and equity incentives. That's probably for a CEO or higher level. So generally speaking, just don't ask about salary history, okay? And then there are remedies that the person can bring if you do violate this law, and there are lawsuits. So basically, review your application now, and remove any questions regarding salary or salary history. With regard to criminal history, as many of you know, Connecticut has had the ban the box law on the initial application for a couple of years now. So you may not ask on the initial application whether they have any criminal history. Okay, so that has to be taken off your application. It does not apply if an employer is obligated to pursue a federal or state law to ask about such criminal history for the position in question, and that often involves banks, for example, or a position which involves security fidelity or an equivalent kind of responsibility bond. Or I've had people say, well, what about in the situation where, it's a customer service agent, but that person's going to have access to somebody's financial information. And I say, well, here's the thing. It's ban the box, which means you cannot ask it on the initial application. This does not foreclose a criminal background check or a secondary kind of application or questioning. So the statute specifically says initial employment application. So now we're talking about the red flags on the initial screening. If your application is compliant with state and federal law, and you've reviewed them and you are sure that you're doing everything correctly with regard to the questions on the application, then you go through your screening process for the application. Some people use computer programs that match the qualities or qualifications of the job with the words on the application. If you're using one of those systems, that's a very highly sophisticated system. Most employers that we deal with are doing this manually, and so they're looking for, matches on certain things. Depending on the kind of job, it may be a red flag that there are short periods of successive employment. If there's a big gap in their employment without explanation, if there's been, most people are not going to indicate if they've been demoted on their application, so that's probably not likely. But if there are discrepancies in the application materials, if things are not adding up, then you have to be careful about that. Many people are also not going to reveal that they were terminated. They just won't say it, so it's sometimes hard to assess that. But so with regard to whether somebody is qualified for the job, obviously you want to have a match that works well, but you don't want somebody who's overqualified to the point where they're not going to be engaged with the job because they would be bored. And I would just caution on the overqualification. Be careful with that one, because you have to really look at the functions of the job versus what the person's qualifications are, what they can do, because there could be a correlation between overqualified and age. So you don't want to get into a situation where you say, well, this person, that a person can come back to you and say, this was an age-related hiring decision, and then you come back and say, well, you were overqualified. It's fine if you can say that you were overqualified, if you can point to the specific reasons. What you'll find both in the hiring process, both for the ADA and for any other kind of protected category, is look at the essential functions of the job. It's all about the job requirements, and whether this person meets the job requirements. As we all know, if there's a discrimination claim, it's going to be about why this person's qualifications were better than the person who's bringing the claim and was not hired. So this is why we started with the job description and the essential functions, because it really informs the entire hiring process. Another red flag, just to go back, quickly, is that, generally speaking, if there aren't any references listed who were supervisors, the person lists only references from family members, that would probably be a red flag as well. Okay, so I started getting into this idea of the legal risks in the hiring process. And obviously we have a number of different legal risks here. The big ones I see right now are the ADA. A lot of ADA issues are coming up in the employment hiring process. Also age-related issues, like I said, with somebody who's saying you knew my age, even though you didn't ask for it because you knew what year I graduated from college, for example. Well, okay, we know what year you graduated from college. That doesn't necessarily always correlate to age. And this is why we say, look at the qualifications. That is always your best defense, and it's always the best way to proceed in a hiring situation. So all of these things I think are important, and I think that if you are tying the application and hiring process to the qualifications of the job, that is your best way to avoid any kind of lawsuit in this area. But with respect to the ADA, you may need to accommodate, and you may find out about a disability in the hiring process, and you have to enter into the interactive process during the hiring process if this person is otherwise qualified for the job.
Okay, so once you've completed screening your applicants, you'll likely be ready to start calling people in for interviews. And interviews are obviously a vital screening tool for all of your applicants. This is the way that you're hopefully going to be able to assess an applicant's communication abilities, their demeanor, their emotional intelligence, and all of these different components will help shed light on whether or not the candidate is going to be a good fit, not only for the position that you're looking to fill, but also for your organization more generally. Is this person going to fit in with the culture of your workplace? In terms of structuring the interviews, studies show that having multiple interviewers, whether the interviews are conducted individually or by a panel, that multiple interviewers will result in better outcomes because multiple perspectives sort of serve as a check on individual biases that might come up during an interview. In terms of conducting successful interviews, preparation is key. You not only want to thoroughly review all of the materials submitted by the candidate, but you also want to take a look at that job description. You want to make sure that you understand both the essential functions of the job that you're looking to fill, and you're looking at what are the skills, the qualifications that the candidate has that might be a good fit for the job. Reviewing a resume as you're walking into an interview or during the interview is not going to produce the thoughtful types of questions that will enable you to assess the candidate in a meaningful way. So putting in a little bit of time up front is going to produce better outcomes for you. So good preparation is also key because it's going to help you avoid inappropriate areas of questioning. If you review the application materials and the job descriptions thoroughly, you're going to have a good understanding of what the position is you're looking to fill entails, and you should have plenty of sort of safe topics to discuss with the candidate. We're obviously all human. We want to connect with people on a human level, but what's important to keep in mind is that even assuming question can lead us down a risky path. For example, this time of year, we might be inclined to ask, how was your holiday? This can lead to information about the candidate's religious affiliation, whether the candidate has children, and other information that exposes aspects of the candidate's life that just don't need to be considered or brought up during an interview. So not, all of the areas that we list on this slide are going to be context specific, except for some questions like salary history. We know that's a no-no. But for the most part, the topics that you see on this slide just are not appropriate for an interview.
I think, again, the whole thing here is to tie the interview as much as possible to the qualifications for the job and the person's history with regard to those kinds of qualifications and what they did at their former jobs. I have had situations where somebody will offer up their criminal history in an interview because they couldn't put it on the initial application because it wasn't asked for, which it shouldn't be. And then the person just, I think the best approach to that is, okay, thank you for letting me know that, and then move on. Don't question in detail about it, because if you're going to do a background check anyway, you'll see what the background check is, and then you can come back and discuss it with the person. I have had employers who hire somebody, in part because they were honest and forthright about their criminal history. Just so you know, when you do the background check, you'll see that 5 years ago, I was arrested for a DUI, but that's never happened again, you'll see, and I, have not had any issues with that. If the job doesn't require driving, then that may not matter to you as an employer. And so, on the other hand, if the job does require driving, I have had, and driving, let's say, people, you might, question that and say, okay, thank you for letting me know, but then when you see that actually happened, you may make a different decision. So, to Martha's point, this is a lot of these things are very context specific, and that's why you have to think it through and consider the risks and benefits on all of these things with regard to issues that are spotted during the hiring process.
So once you have interviewed your candidates and you've whittled down the group and identified someone who's going to be the best selection for the role, you'll probably be ready to draft up an offer letter. The offer letter should contain certain pieces of information, basic information, rate of pay, hours worked, which is really more important for your non-exempt employees who will be working set hours each week, what the pay schedule is, weekly, bi-weekly. It's a good idea to remind in the offer letter that this is an at-will position, assuming that it is an at-will position. And then most importantly, you want to state in writing whether there are any contingencies that the offer is based on. So is the offer contingent on the successful completion of a pre-employment drug test, medical examination, background check, etc.
So if you're going to perform any background checks, the most common one is an general overview background check. Often people will hire third-party agencies to perform those. I think that's a good idea because then it's just being sent to an outside company who will do it. The employer may itself ask for references from prior employers. There's the criminal history background check, which will come back as part of most third-party background checks. Credit history is somewhat limited in Connecticut, so you have to be careful with that one. Social media is something that you can do yourself, but again, you have to be careful on the limitations and what you ask for. So for reference checks, as we said earlier, you can ask for references on the application, and you can call them. But most companies, if you, as my client, are giving a reference check, I'm going to advise you just stick with the statutory criteria that are allowed, which is basically last position held, dates of employment, and the statute says salary, but you can no longer, as an employer, ask for salary information, so you probably shouldn't be providing salary information. And so depending on which side of it you're on, if you're asking a former employer for information to confirm dates of employment, position held, don't ask for salary, and say explicitly to them, do not provide me with any salary information, because you do not want to have that salary information. You're not supposed to have it, and you can't use it. So if you obtained it, even inadvertently, and you didn't hire that person, arguably they could have a claim against you. So the statutes have not been, the new statute is at odds with the old statute in that regard of salary history. But, so for reference checks, I think that they're probably of limited value, because most employers are not going to provide that much information. If you happen to get somebody who is willing to provide more information because you've obtained a release from the employee to speak with their former employer, and the former employer is willing to speak with you beyond the statutorily allowed topics, then obviously you can ask, as many open-ended questions as you want about the person's work performance. So, I'd be actually interested to know how many of you, if we were in a room and I could see your hands, obtain valuable information from reference checks. But you can, particularly if you have an authorization from the employee and you provide that to the former employer, and the former employer talks to you. Even with a release or an authorization from a former employee, I counsel my clients to be very careful and just say, look, we follow the statutory rules, so we don't provide any additional information, particularly with a bad candidate. So, that's again, a judgment call. Okay, as we said, ban the box on the initial application, but depending on the area, of what kind of job the person's going to do, that may not apply. But even though it's on the initial application, it's certainly something that can be done on subsequent applications or a background check.
Credit checks, the bottom line is that credit checks are really pretty limited under Connecticut law. There are certain categories of employers or types of roles within an organization that might be permitted or permit the use of a credit check, but by and large, credit checks are not going to be a component of the background check for most run-of-the-mill employees. Okay. Got a couple of slides on social media searches. The first covers a statute that's been on the books since 2015 that prohibits employers from requiring the disclosure of login information for both employees and for applicants with respect to their personal social media accounts. It also prohibits what's called shoulder surfing, so you can't require an employee or an applicant to log into a social media account while you're standing over their shoulder and watching what they do. And you can't require an employee or an applicant to accept a friend's request. And so I think that this is sort of what's significant for purposes of the hiring process. As an employer, you can't create sort of a fake account and go on social media and try to friend or connect with applicants and gain access to social media information that way. That would still be considered illegal for purposes of this statute. So there are some hefty repercussions for violating the statute, which are listed on the slide. This obviously doesn't apply to, for example, an employee who runs a social media account on behalf of your company. The employer is then well within its rights to ask for login information for those types of accounts. This really just applies to personal social media accounts. The next slide, if you are going to conduct searches into an applicant's use of social media, what's publicly available, because as we know, we can't go around friending applicants under fake accounts. If you are going to use social media searches, be careful, because just like with innocuous interview questions, by searching for someone's social media account, you can quickly become aware of personal information that's going to be indicative of the applicant's race, gender, family status, marital status, sexual orientation. There's so much information that's available through social media that has no real bearing on the candidate's ability to perform the essential functions of the job. So you have to really tread lightly. This is sort of a TMI, too much information type situation. And the issue is that the optics can be bad. If you fail to hire someone after having conducted a social media search, the implication could be that you based your hiring decision off of information that you gleaned from social media. And so you want to avoid those situations. Another consideration to keep in mind, if you are going to perform social media searches, you don't want to do it on sort of an ad hoc, case-by-case basis. You really, if you're going to do social media searches, they should be performed consistently and likely based on a written standard policy, because again, the optics are not good if you are electing to perform social media searches only on certain applicants. There can be sort of a disparate impact type issue with those types of decisions. So tread lightly with the social media searches. I've read studies that say that employers are starting to back away from looking at social media use, especially because you never know what can really be attributed to the owner of the social media account. It's just maybe not the best information to base hiring decisions off of. It's going to be context specific. If you're hiring someone to run the Instagram account for your business, try to find the Instagram, any social media work that the candidate is doing for their current employer, rather than relying on what they're putting out there on their personal account.
Okay, pre-employment medical exams. Again, under the ADA and the Connecticut Fair Employment Practices Act, an employer may not ask a job applicant to answer medical questions or take a medical exam before the employer makes a conditional offer of employment. So this is where we started in the offer letter. If you're going to require pre-employment medical exams, it must be referenced in the offer letter that the offer is contingent on your passing a pre-employment medical exam. Now, what does that mean? What does that mean, passing a pre-employment medical exam? So again, the medical exam has to be tied to the essential functions of the job. For example, if there's a lifting requirement and the person cannot meet the lifting requirement, then you have to engage in the interactive process and see if there is an accommodation for that. Often for lifting, depending on the what kind of employment the person is going to be having, there may not be any kind of modification for that. So it's the type of thing where in the pre-employment exam, you're going to get information frequently that may need to be addressed under the ADA. Sometimes something is a strict disqualification. Sometimes there are workarounds, but you have to consider that with each factual change in the situation. So the drug and alcohol testing, an applicant must be informed in writing at the time of the application of the employer's intent to conduct a drug test. As a matter of fact, probably all of this should be on the application, the pre-employment medical testing, the pre-employment drug testing, because it's just the best practice to inform a person of what they're going to have to go through in order to get the job. So if there's a positive test, the prospective employee must be given a copy of the positive test results, but it must be kept confidential by the company. And so the big question is medical marijuana. So all of the third-party drug testing companies rule out a prescribed prescription by a doctor. So what they aren't doing is to rule out medical marijuana. So what I've seen is that they push this back onto the employer. So if the person is on some kind of prescribed medication, the employer may not learn about it. If the person's on medical marijuana, the employer will learn about it because the drug testing company doesn't want to deal with it since it's illegal under federal law, but in Connecticut at least, and many of the states now, it's legal. So in Connecticut, my advice is that you must treat medical marijuana the same as any other prescribed medication, and you cannot straight out refuse to hire somebody because they've tested positive for medical marijuana on a pre-employment drug screen. And it may require the interactive process. We have a whole seminar on medical marijuana, which some of you may have attended, but among other things, it does allow you to prevent somebody from, it allows you to not hire somebody who's on medical marijuana if they have a federal position that does not allow medical marijuana. So that is one of the exceptions, but if you don't fall under that exception, then an employer is going to have to deal with it in the interactive process. So I kind of already addressed this fact that if you have pre-employment drug screening, if you have pre-employment medical examination, you're likely to get information that may have to be dealt with in terms of whether you can accommodate the person's disability. Even if you don't do any pre-employment medical exam or drug screening, you may have somebody who reveals to you that they have a disability, and then you will have to enter into the interactive process. Once you are told about the disability, you have to consider it, and you have to consider whether there are any accommodations, and you cannot simply refuse to hire somebody because they've revealed that they have a disability, and this is where the documentation on the interactive process is extremely important. But the thing is, if the person in the first instance does not even meet the basic qualifications for the job, and they put, for example, on their application, that they had a disability, but otherwise they were not going to be qualified at all for the position, then I'd say, look, it's very clear from the application that they're not qualified, so there's no need for an interactive process. You're never going to ask if they have a disability on an application if they just happen to offer that. You first look at qualifications. Are they qualified for the job? If they meet the qualifications, they got through the interview process, during the interview they revealed to you that they had a disability, then you simply have to say, take that information and determine next steps. Would it be possible to engage in the would it be possible to accommodate the disability? But you do have to engage in the interactive process. Should you engage in the interactive process right then and there in the interview? Probably not. You probably, depending on who's doing the interviewing, particularly if it's a manager, no, that person should not be the one to engage. They should simply say thank you for that information, and we'll get back to you. And then what I find works well is that the manager provides that information to HR, and then HR can work with the manager and determine if there is reasonable accommodation that can be made. But all that really needs to be documented, because the primary thing that courts are looking at right now in the ADA is the process itself. So the more process, the better. The more documentation of the process, the better. And that's what I think you need to do with regard to the accommodation issue in hiring. I guess we're moving forward to see now if anybody's submitted any questions.
Question is, can we ask about salary requirements or expectations?
I wouldn't. You know, it's one of those gray areas. What I prefer, here's how I would do it. This job, I would state what the job pays. So this job pays a range of, you know, $15 an hour to $20 an hour. Would that meet your expectations? Or this job pays $15 an hour. Would that meet your expectations? But you're probably not, you may not even get there until later in the process. So the other way to do it is you just offer, make the offer, and then see what the response is. But saying expectations is not the same as saying what did you used to make. So I guess it's not strictly prohibited, but I just think again, it's kind of a risk-benefit analysis. If you raise history in an interview, I would not put it on an application. I would not put salary expectations on an application. I think it's too open to misinterpretation and could be used against you. In an interview process, if you ask salary expectations, say, I don't want to know what you made, I don't want to know your salary history, but what are your expectations for this job? I guess you could do it that way. It's not per se illegal. I just think that when you enter into that whole line of questioning, you have to be careful because people could misconstrue it if they don't get the job.
And the whole purpose of the statute is to try to stop the perpetuation of basically women earning less than men in comparable positions. And so the onus is put on the employer to figure out what does this job pay versus what can we pay Susie versus Bob to do the same job. So you're going to need to do sort of a pay audit to figure out what does this position, what's the value of this position. It shouldn't matter whether it's a woman or a man or a young person, old person, whoever is doing the position. Each position should have a value or a range of value. And so the legislature is trying to put the responsibility on the employer to figure out what the value of the position is rather than having the candidate sort of create the value of the position by disclosing what they've made in the past and having that inform what the ultimate offer is.
Okay, the next question. My understanding is that the former employer is not allowed to disclose salary, only dates of employment and whether employee left. Right, so there's a conflict in the old statute. The old statute allowed salary information to be disclosed, the old statute that's currently on the books. And that has not been modified to be consistent with the new statute as of January 1, 2019, where employers cannot ask about salary history. So I would advise, there's nothing to prevent the former employer in the current statute from disclosing salary information. However, the new employer or the prospective employer should never obtain that information. So there's no reason why it should be provided. So I just would say the risk on obtaining that information is more on the prospective employer, and the former employer is doing the prospective employer a favor by not disclosing it. But I think the best practice is you just stay away from it on both sides. If former employee wants a reference and provides a full release, should we release performance information? Okay, so as the former employer, I think that you can, So there are always risks in releasing any kind of information, even with a release of claims. And so, or an authorization, because the risk is the person doesn't get the job and then they come back and say, oh, well, that was because you said something negative. And so, you know, does the authorization completely eliminate risk on the employer, the former employer providing the information? No, it does not completely eliminate risk. However, if you have something in writing that's consistent with what the employee received during the course of the employment, so that they know what it's going to be, some kind of summary of performance or something, or their last performance review. If you want to reveal that confidential information, I'm not sure I would. If you want to simply say, you know, their last performance evaluation was meets expectation, and okay, I think there's still risk involved. And so I think this is not a black or white question. This is a question of how much risk do you as the employer want to take on in providing anything in addition to the very basic information of last position held and dates of employment. Can you ask if the candidate left a prior position voluntarily, was laid off, or furloughed or discharged for cause? You can ask that. Yes, you can. How does the Drug-Free Workplace Act conflict with Connecticut's laws? We are a federal contractor. Okay, so if you're a federal contractor, the federal law is going to govern. The Connecticut, for example, the Connecticut medical marijuana PUMA explicitly carves out federal contractors. So you have to abide by your obligations under federal law as a federal contractor. State-specific application. So Connecticut does not have a state-specific form. So that would just have to be something, you know, if you have an application, we can review it for you to confirm that it's compliant with Connecticut law, but Connecticut does not have a specific application where it would say, here, use this application. Okay, there are 4 reasons that a CNA cannot be hired by state law. Should this be noted on the application? You know, you don't have to note that on the application. They probably should know that if they're a certified CNA, what the reasons are. I think a lot of CNAs go through pre-employment medical screening, drug testing. So if you're going to put them through those kinds of screening processes, then I think you could say that on the application. In other words, the job is contingent on pre-employment application, pre-employment drug testing, pre-employment medical testing. I'm not sure that I would just say, you know, you cannot be hired as a CNA if 1, 2, or 3. I think what it is that you want to notify them of what they have to do in the process in order to be hired. Okay, thank you so much for your questions. I think they were excellent. And we hope that you found this information helpful. As I said at the beginning, you will be receiving an email with the PowerPoint slides and a link to the webinar and an attendance certificate. If you have any other questions, please feel free to email me or Martha, and we'd be happy to have further discussions with you.